Let's stick with eyewitness testimony. Previously, we noted that we're trying to get juries to attend to how confident we should be in what they're saying, not how confident the witness is in what they're saying. The judge must instruct the jury members regarding the frailties of eyewitness testimony, and instruct the jury to consider concrete practical aspects of the eyewitness's circumstances. This caution to the jury is specifically referred to as a Hibbert Instruction. In R.V. Hibbert, a real estate agent was assaulted by a prospective client as she was showing him the garage. He was convicted based on her identifying him and other evidence like his DNA on a hat found along the escape route. On appeal, it was found that the judge had not cautioned the jury sufficiently against eyewitness frailty. Since this was not the only or essential piece of evidence in the case, the charge against him was still upheld under Criminal Code Section 686, subsection 1, paragraph B, subparagraph. But R.V. Hibbert gave us the following often quoted line about the very weak link between the confidence level of a witness and the accuracy of that witness. After which, there's a rather explicit acknowledgement of retrieval-induced forgetting or overwriting of memories. Here it should also have been stressed that the impact of Mrs. McLeod having seen the appellant arrested by the police as her alleged assailant could not be undone, nor could she be expected to divorce her previous recollection of her assailant from the mental image that she formed after having seen the appellant on television. In other words, subsequent events may have broken or overwritten her original memory. It is our job as seekers of truth to point this out to the jury. Canadian courts have even gone a step further and explicitly acknowledged not just the weakness of the link between eyewitness confidence and accuracy, but the danger of certainty in eyewitnesses, and the need to be consistent in cleansing jury members of the idea that eyewitness confidence is to be given any weight. Quote, certainty on the part of an honest identification witness is part of the reason that eyewitness identification evidence is dangerous. But a highly confident witness is not the only biasing factor of eyewitness testimony. There's also the reputation or perceived credibility of the witness. If Neil deGrasse Tyson is on the witness stand telling us what he saw, we're likely to believe him more than other people. And maybe you could come up with lots of good rationalizations for why you should. He's a scientist, so he has training in error and cautious interpretation. He's intelligent, so he will likely understand the ramifications of his testimony. Yet, even if we believe these rationalizations, the following are still true. His testimony is more likely to be reliable if he knows the person he's identifying, he had a longer time to look at the person, he was not under stress at the time, he gave specific and distinct details in his initial testimony and identified the person early on before memory corruption took place, before he was coached by legal counsel in how to be convincing and eschew doubt so as to be taken seriously. But note that that last bit isn't in the frailties. It is not required that the judge warn the jury about specific processes or individuals or contextual factors that might have pushed the memory or individual's confidence in the memory towards certainty. If we can do it with confabulated and implanted ones, we can of course do it with gray area fuzzy types of memory, where somebody kind of looks like the person that you saw. Before we move on to issues of coaching, memory corruption, memory implantation, let's take a look at R.V. Jack and see how the psychological research and its findings that at least the court has seen as established translate into actual arguments in the court process and appeals process. Chadwick Jack was accused of robbing with a gun an auto hire rent-a-car, from which the robber took $2,500 from the owner and $50 from a customer. The victims believed the robber to be Chadwick, a customer they had previous dealings with, and produced for police this information when they arrived from that previous transaction. Since no fingerprints or video surveillance were available, the case was determined primarily by witness identification provided by the two victims. The relevant legal problems raised on appeal of Chadwick Jack's conviction were that the witnesses gave very vague descriptions to police, a 5'8" or 5'9" black male, and when asked whether they recalled anything distinctive about the robber's appearance, they both said no. One might think that this should not matter much, since from their perspective they had recognized him as a customer they dealt with previously. Sure, they did not give a good description, but they remembered him and went and got actual receipts from previous interactions with him. But they had also explicitly stated that they did not recall anything distinctive about the robber's appearance. And Chadwick Jack has 2 permanent gold front teeth, a 7-inch scar on his jaw, and a 3.5 centimeter tattoo on his left hand. So the argument now becomes about what a normal person would have recalled. Surely, if someone points a gun at you with gold teeth and a long scar, you would remember the teeth and scar, right? Note that now, the judge's duty to instruct about the frailties of eyewitness testimony is being applied to possibly judging something as too frail to be accurate or not good enough to be a real memory. On the surface, it's a simple point that the judge didn't say don't trust vague descriptions, but reading the actual document, the implication is that it would have made a difference in this case because the victims should have remembered gold teeth and a scar. One might expect the judge to caution about imperfection of memory. Less expected is the extension of this to saying that the memories were too imperfect for the identification to be accurate. Real memories are bad ones, but this one is too bad to be real. For citations relevant to the failure to mention distinctive characteristics, see paragraph 29. Since the specific issue under consideration here is just what the judge should have said to instruct the jury, here is what he said. The case against Mr. Jack depends entirely on eyewitness testimony. You must be very careful when relying on eyewitness testimony. In the past, there have been miscarriages of justice, and persons have been wrongly convicted because eyewitnesses have made mistakes in identifying the person whom they saw committing a crime. Eyewitness testimony is an expression by a witness of his or her belief or impression. It is quite possible for an honest witness to make a mistake in identification. Honest people do make mistakes. An apparently convincing witness can be mistaken. So, what, according to the Ontario Court of Appeal, is wrong with this? Paragraph 21 notes its failure to adequately deal with the reasons why, on the evidence in this case, the identification evidence had to be scrutinized with considerable care. The most notable of these problems was that the victim's contact with the robber was brief and stressful, and their descriptions of him were generic in nature, lacking any mention of any distinctive features. Paragraph 25, previous contacts between the victims and the appellant took place months earlier, were brief, and were in the normal course of business, such that the men would have no particular reason to have made note of the appellant's features. The best evidence of this is that neither witness remembered observing anything distinctive about the man's face. Note that everything seems to circle back to the guy's face.
So most of you didn't feel you remembered anything about the face at all? Wow.
Paragraphs 27 to 29. Second, the charge did not provide the jury with adequate assistance on how to assess the reliability of the victim's description of the robber, given that their descriptions were generic and did not contain any reference to the appellant's distinctive features. The gold teeth, the scar, and the tattoo, features that would have been apparent given the proximity of contact with the perpetrator and his victims. 28. Admittedly, the trial judge did instruct the jury to consider the victim's failure to notice the appellant's distinctive features. Okay, so what's the problem? After summarizing the evidence relevant to this issue, including the fact that the arresting officer testified that he did not notice these features when he located the appellant several weeks after the robbery, hang on, you're telling me that someone who is especially trained to notice things also didn't notice these features? The trial judge instructed the jury as follows. Are the gold teeth, facial scar, or hand tattoo something that the two eyewitnesses should have noticed? If indeed the robber was Mr. Jack, does the failure to do so raise a reasonable doubt about whether Mr. Jack was a robber? This is for you to decide. Oh no, don't let jury members think for themselves. However, I agree with the appellant that this instruction did not go far enough. Specifically, what the judge said does not qualify as a Hibbert instruction because it did not explicitly warn against the very weak link between confidence and accuracy. And, paragraph 38, 2 eyewitnesses gave an in-dock identification that the appellant was the assailant. The heightened risk was that with 2 in-court identifications, the jury would attach increased unwarranted weight to this evidence. There was therefore a need for the jury to be specifically cautioned in a manner that not only conveyed the untrustworthiness of in-dock identification evidence, but also brought home to the jury the danger of allowing evidence the nature of which is so fundamentally unreliable. The conclusion and disposition. As I have said, the victim's identification provided to the police immediately following the robbery was problematic. The victim's subsequent in-dock identification of the appellant as the assailant did not add any weight to this initial identification, and the Crown led no other direct or circumstantial evidence connecting the appellant to the robbery. In these circumstances, I conclude that the identification evidence was insufficient to support the verdicts. A properly instructed jury, acting reasonably, could not have found that the identification evidence in this case met the requisite criminal standard of proof. That's a testable hypothesis. Disposition. Given my view that the verdicts are unreasonable, the appropriate order is an order quashing the convictions and entering an acquittal on each charge. So there it is. The Court of Appeals decided not to trust the 2 victims. And when jury members did trust the victims, the Court of Appeals decided not to trust the jurors, who surely would have agreed with the appeals judge if they'd just been given the more precise, established instructions. A properly instructed jury, acting reasonably, could not have found that the identification evidence in this case met the requisite criminal standard of proof.
Inconceivable.
In the absence of other evidence, the eyewitness testimony was not deemed to be reliable enough to hold up, and so Chadwick Jack was acquitted. This example shows how concepts and precedents are used in courts, and the high standards followed and upheld by courts of appeals. If 9 guilty people have to walk free to prevent 1 innocent person from losing their liberty, the court is okay with that trade-off. One may disagree when thinking about things from the perspective of the victims or the witnesses, which is why I chose this case as an example. But if we remind ourselves that we're trying to make sure innocent accused people do not themselves become victims, hopefully we can agree that the 9-to-1 rule helps to prevent tyranny, injustice, and oppression on the grander scheme, even if it seems otherwise in given cases. Now we move to consider just how intense the battle for the minds and memories of jury members and witnesses is. The absurd world that jury members must enter and navigate their way through. As mentioned, the corruption of memories through coaching by lawyers, training by consultants, and coercion by investigators is not one of the frailties or dangers discussed in the Hibbert caution. It is one of the issues we trust jury members to determine on their own. Whether the issue is raised by Crown, defense, experts, or not at all, it's up to jury members. Experts might be consulted by the defense or prosecution to inform the court about such things, but what if what these experts have to say is diametrically opposed to what some other experts are presenting in court? We move on to issues of coaching, memory corruption, and memory implantation with one of the cases that best describes human irrationality. Those who think that witch hunts could not happen in North America simply need to update the term witch for something currently feared and hated. Switching witch for pedophile or racist shows us that mass psychology has not improved very much. Not because pedophilia and racism do not exist or are not evil, but because we are irrational or injudicious in face of accusations of these things. A quick way to lose friends in today's polarized age is to state that due process should apply to everyone. You mean everyone but witches, right? We can't have them running around. They have magical powers to corrupt innocent people. Their power causes harm. You don't like harm, do you? There's no due process for witches, right? So let's look at a case that ended up with 105 charges being laid against 7 people on the first trial. In the second trial, it was 65 leveled against just 2 people over the course of 7 years. This is Ray Busey, 25-year-old employee of the McMartin preschool.
They had a great reputation. They had been in town ever since I can remember.
There was actually a waiting list
They had colorful toys in the yard, so the kids were all drawn to that.
The year is 1983, and Judy Johnson is concerned about her son's anus. In 1985, she will be diagnosed with paranoid schizophrenia. For now, she is a concerned mother, recently separated from the husband, calling the police on August 12th to inform them that her son's anus had not been read when she sent him to school, but it had been read after he came home. She believed that her son's report that he, Matthew, had been playing doctor with the other children corroborated her suspicion that Ray Busey must be molesting her son. Aside from the fact that Ray Busey was a male and had, according to Matthew, introduced the idea of playing doctor to the children, there was nothing else to substantiate this phone call.
Police Department.
My name is Judy Johnson, and I want to report a crime.
Yes, ma'am.
My 2-year-old son has been molested at the McMartin preschool.
Days later, she called again, informing police that the son, Matthew, had identified 2 other individuals who she said were victims of Ray Busey. The next day, Matthew was physically examined by the Marion Davies Children's Clinic at UCLA. They also suspected child abuse, and a warrant was issued for Ray Busey's arrest. Judy Johnson took it upon herself to call other parents, including one of the 2 named by Matthew, who reported that he didn't like Ray but hadn't been molested by him. The detective Judy contacted was also calling parents of McMartin children, all of whom reported nothing wrong. But Judy persisted, and the police searched 2 homes for any evidence of pornography, trophies, or images of molestation, finding nothing but holding Ray briefly and releasing him only on $15,000 bail. Having nothing but Judy's report, the police issued a letter to the 200 households with children currently or previously attending McMartin that read as follows. So this is almost 4 weeks after her initial call. Dear parent, this department is conducting a criminal investigation involving child molestation. Ray Busey, an employee of Virginia Martin's preschool, was arrested September 7th, 1983 by this department. The following procedure is obviously an unpleasant one, but to protect the rights of your children as well as the rights of the accused, this inquiry is necessary for a complete investigation. Records indicate that your child has been or is currently a student at the preschool. Please question your child to see if he or she has been a witness to any crime or if he or she has been a victim. Our investigation indicates that possible criminal acts include oral sex, fondling of genitals, buttock or chest area, and sodomy, possibly committed under the pretense of taking the child's temperature. Also, photos may have been taken of children without their clothing. Any information from your child regarding having ever observed Ray Busey to leave a classroom alone with a child during any nap period, or if they have ever observed Ray Busey tie up a child, is important. Please complete the enclosed information form and return it to this department in the enclosed stamped return envelope as soon as possible. We will contact you if circumstances dictate same. We ask you to please keep this investigation strictly confidential because the nature of the charges and the highly emotional effect it could have on our community. Please do not discuss this investigation with anyone outside your immediate family. Do not contact or discuss the investigation with Raymond Busey, any member of the accused defendant's family, or employees connected with the McMartin school. There is no evidence to indicate that the management of Virginia McMartin's preschool had any knowledge of this situation, and no detrimental information concerning the operation of the school has been discovered during this investigation. Also, no other employee in the school is under investigation for any criminal act. Your prompt attention to this matter and reply no later than September 16, 1983 will be appreciated. Harry L. Kuhlmeyer, Jr., Chief of Police. John Wiener, Captain. While we could, at this point, criticize the police service's handling of the issue thus far, or smear the concerned mother for her beliefs or the nature of her persistence, what likely caught your attention is the reference to the UCLA clinic. Matthew was physically examined by the Marion Davies Children's Clinic at UCLA. They also suspected child abuse. Medical professionals identified something of sufficient concern about Matthew's body, something consistent with their understanding of molestation.
The children were referred to CII's doctor, Astrid Hager, who was a reported expert in child abuse examinations.
My role in this case was to be the medical doctor that examined the children for evidence of abuse. I got involved in the McMartin case because I had began to question the issue of why child sex abuse cases never went to court or rarely went to court. And I'm going, how are you documenting? You're just documenting on a piece of paper. You're writing down what you see. And that's not scientific. Nobody had ever taken pictures before. I realized we needed to do photo documentation, and then that became evidence.
My son was physically examined, and they said that he was very likely sexually abused. That was their words. I was so angry and so hurt and so sad. I sat in my car wanting to drive it through the McMartin building. And I wanted to just kick their ass, frankly.
We had Elizabeth examined by Astrid. She said there was enough physical evidence to claim that there was something happened.
More important than Astrid Hager's pictures were her verbal descriptions or conclusions regarding what the pictures mean, and these were informed by two things: theories of a researcher named Woodling and her limited experience assessing abused children. Not assessing any control groups of non-abused children, just abused children. Before you think that I am painting her as evil or incompetent, keep in mind I am well aware that she had the best of intentions. Just as Woodling had the best of intentions, the very best of intentions, when conducting his research. This is the research that informed Astrid Hager's analysis of the children sent to her for assessment, and the analyses of those of her colleagues. It is what we would politely call confirmatory research, i.e. research with the intention of finding a specific thing, evidence of chronic abuse. He had been working on call as an examiner of rape victims. He became known as an expert and then dedicated himself to research trying to find evidence of chronic abuse in children. Chronic abuse being the types of non-physically scarring molestation that would be difficult to physically evidence. He came up with two big ideas. The first he dusted off from the 1800s, which was known as the wink test. The premise of which is if you touch an area around an individual's anus and that anus opens, it has been sodomized. The other is the idea of microtrauma, which, thanks to something called a colposcope, a magnifying camera that may be placed in the colon, he could look for tiny marks and scars. He specifically combined this with other pseudoscience about hymen, and the wink response test had of course been debunked before he reintroduced it. But these are the two concepts that Woodling introduced, that Astrid Hager's medical analyses commented on, and that, importantly, never made use of control groups. This is likely why Hager concluded that 80% of the children she saw had been abused. Let's consider for a moment that Judy Johnson, the police, and the medical consultants could be wrong about the existence of abuse, in general or in some cases. Anyone introduced to the basic ideas of confirmation bias and memory fallibility will know that at this point, any errors made by Judy Johnson, the police, and the medical consultants are going to get much worse before they get better. And the jet fuel that got poured onto this confirmatory analysis fire comes in the persons of Key McFarlane and Wayne Satz.
There's no doubt in my mind, on the basis of the children that I interviewed, that approximately 350 children that we saw described being sexually abused.
I think they were questioned by the older people until they finally said yes, agreed to it.
So you think you're just being framed, huh?
You darn tootin' I think we're being framed. I don't think it, I know it.
The DA was under pressure from the parents to have charges filed. We had medical evidence, and you have children saying they were abused. So what's left to question?
Not much is left to question when you prevent the expert who has a control group that shows that most of the medical evidence that they concluded was consistent with abuse is found in most non-abused kids, including the wink response and microtraumas. But what did seem to be effective in the court is presenting what was done in the actual interviews, which it does not take a degree in psychology to see were very misleading. When this child says that she has not seen Ray Busey's penis, the response is, "You're just a scaredy cat. How come you won't tell me?" When this child says they didn't play the naked game with Ray Busey, the response is, "You're just not smart enough to remember. Are you dumb? You must be dumb." Here she is, first directly lying to a child about what the child's friends said, and then directly telling the child that the child had played the naked games. And this is after clear and direct negative responses to the questions she was asking. The child has already said no.
Children's Institute never thought ahead that, hey, one day the tapes are going to be revealed and everything that took place in this room with this child is going to be part of the criminal record. I don't think they anticipated that. And once they learned that it was going to happen, all hell broke loose. They did not want the defense to see what was going on during those interviews. That was real clear.
There are also the more basic corruption of memory issues here, because all the kids had been warned about Ray Busey by this point and asked about those very specific things listed in the police letter, and being charitable to Key McFarlane, who again had the best interests of children in mind. I'm sure she probably saw the effects of that letter in the children's attitudes and feelings when being questioned, their surprising choices of words that they would not have encountered absent being questioned about those things by their parents as requested by the police. So we should be able to understand everyone involved in the process as a reasonable actor. And yet, things got out of hand. In part because this journalist, Wayne Satz, broke the story, spreading it wide and far, letting it become a social contagion and panic. Deemed not relevant to the trial was the fact that he was dating Key McFarlane at the time of the trial and news coverage. What I would like to emphasize is the runaway process here. Ray Busey and others were being held without bail based on the UCLA clinic's opinions of the medical evidence and social worker Key McFarlane's interview results. If you're having trouble identifying with or finding sympathy for Ray Busey, who some of the internet still thinks is guilty, consider some of the other suspects turned into victims of this social process.
When I first met Peggy Ann, she was alone in the men's lockup. She was bright, young, late 20s, articulate. She knew what was happening, but she couldn't understand it. She was bewildered, dazed in a way.
She's a sensitive, community-serving individual. She's got a master's in rehabilitative education. She teaches the handicapped, more recently the deaf, in Orange County. She's locked up without bail.
How could she be remanded to custody without bail, as were her mother and brother, on the fanciful accusations that were being made in the case?
We believe the children, and to this day, I do not at all discount anything that they said.
I asked my daughter, how did they take you in and out of the school? And she said, through the tunnels.
So should we still believe that there were tunnels even if we hired surveyors to check the ground and to excavate? Should we still believe that there were animal sacrifices of large slaughtered animals cut up with knives in the churches and cemeteries where the children suggested that this happened if we checked those churches and cemeteries for blood and animal remains and found nothing?
Have you actually found any pornography, printed or film material?
That is something I can't get into at this particular point of the investigation.
Okay. He was polling potential jurors, and 90% of the people thought these people are guilty.
I feel like I've been already convicted, and how I go about proving to you or to anybody else that I'm innocent, I don't know, and it frightens me.
So most of the jury pool already has their mind made up, and at the back of the courtroom you have parents and concerned others, all of whom have the best of intentions, holding signs that say, "I believe the children."
They stood there and pointed at Ray Bucky and said, "He's the guy that did this to me."
You don't hate children, do you? That's what matters, right? Aside from the woodling evidence, if you still want to call it that, investigators found zero physical evidence. No tunnels, no animal blood or remains at any churches or cemeteries suggested in testimony, no pornography images that could be matched to the forensic images of children, and they had a recently confiscated cache of child pornography, and they assessed each image of child pornography to compare it to the pictures of the children in the trial. So it was the woodling evidence and interviews. In the first trial, the jury's decision not to find the defendants guilty rested mostly on the biased interview process. The speaker for the jury stated the interview tapes were too biased. In the first trial, Key McFarlane had been a witness for the prosecution. Due to social pressure, since 87% of poll respondents thought the McMartins were guilty, and the district attorney's belief that the jury could easily have gone another way, in fact, the judge was quoted as saying, "I would not have been surprised at any decision that the jury made," a second trial was held. And Ray and Peggy Bucky were charged again. This time, Key McFarlane was a witness called by the defense and not the prosecution. And once again, the McMartins were not found guilty of anything. 7 years, hundreds of damaged lives, a changed culture, because this case is one of the reasons why early educators are dissuaded from hugging kids or otherwise showing affection, lest it be misinterpreted by another Judy Johnston. And what did we learn from it? Did we learn that evil can be done against children, parents, and compassionate professionals even when only pure intentions and safety are being sought? That the reflex to find an evil person with evil intentions behind every bad or suspicious situation can cause evil itself? Did we learn to set aside prejudices and gut feelings in favor of rational evaluation? To detach the horror of the crime from the search for truth about that crime? That injustice can come from satisfying the mob that demands justice? That the right moral postures and beliefs can lead to evil actions and are no substitute for an actual understanding of what one is doing? Did we learn that? This is for you to decide.
Wow.